Hi everyone, I'm Jacqui, I'm the State MP, and I was originally an apology and I do have to run, so I apologise, but I am conscious that I'm coming here with not so great news as well, but it was important that I came and address the new planning regulations that are passing through New South Wales Parliament at the moment. They've passed the lower house, they haven't passed the upper house, but they will, and they're the biggest planning reform in 50 years. Hi Jenny. Biggest planning reform in 50 years and completely flipping planning on its head. Developer-led planning rather than community council-led planning. And I thought I'd just touch on some of the things, and maybe we can tie it over to a newsletter where I can put things in more detail. But I did want to flag it because it has come up with no opposition. So Labor's been working on this with the Liberal Party. It passed the lower house very, very easily. I mean, I think I or the Greens, I can't remember, but we called a division. It didn't need a division because it was quite clear it was getting the support of the two major parties. So Labor and Liberal on one side, and Michael Regan, myself, and two Greens members on the other side. Now, the reason it's so bad, you may have seen in the paper today about Yema's influence and his lobbying from the developer point of view. It is developer-led policy. So what the Act enables is a new pathway, and we don't know what that's for yet because that will be put in the SEPs, but a new pathway that will allow basically developments to go through without a lot of the approvals. The reason you don't get the approvals is that they consider that the approvals are done up front. Now there's one example I can give, and that's the low to mid-rise that we have in Mona Vale. And you may have heard of a pattern book where the government's gone out to tender, designed some townhouses, some low to mid-rises, and so if a developer chooses to use that pattern book, a lot of the approvals are considered done already, and they will most likely have to go through a CDC process rather than a DA process, so taking away community voice. So that's one example, but there's scope for the government to put in more SEPs that have that pathway as well. So there's a lot of uncertainty, and that won't have parliamentary scrutiny. That's basically at the whim of the minister. And one of the concerns was also that those pathways could apply to mining sites, renewable sites. So we at least got an amendment to make sure it's only just for housing, even though that's still diabolical. They also tried to change the objects of the acts to remove the reference to environment a lot. So I moved an amendment that was successful, that I got the government's support on, to reinstate some of those objects because they were waxing lyrical about how this wasn't going to impact the environment, yet they'd actually changed the objects of the act to remove environment. So there's not a lot of things that made sense in what the minister was saying versus what was actually written down in the piece of legislation. So that was a small win, but there will be also and Sue will probably be able to talk to this, the consultation process with community. That's not going to be done on a council by council basis. There's going to be a statewide consultation policy, which given their agenda for housing is probably going to reduce it to the lowest common denominator. So while Northern Beaches has a great community consultation policy, that's going to be run by the state as well. It's also enshrining in legislation the Housing Delivery Authority, which is almost a different version of a state significant development pathway. Through that, it can get spot rezoning as well, and so far 75% of those proposals that have gone to the HDA have included rezoning as well. There's also a new authority which is considered a one-stop shop for approvals. And look, I do understand that the planning system is very complicated, that sometimes it's very slow, sometimes you get conflicting advice. One fire person might say cut down the tree, the arborist says don't. It's meant to be a one-stop shop, which sounds great, and the mum and dad developers will love it, but who loves it more are the big developers. So the problem is there's no transparency as to how the planning secretary, so it's called an authority, but the reality of the authority is it's one person, the planning secretary, or anyone he or she delegates to, but there's no transparency as to how maybe conflicting decisions are resolved and how that decision is made. And there are concerns around that transparency as well. So whilst the minister will say it's nothing like 3A and there are these small minor differences, there are issues with transparency. Obviously, when there's a lot that's taken out of local planning and into the discretion of the minister or a planning secretary, risks of corruption and influence. And so that's not good. So I'm sorry to come here bearing bad news. I suppose the flip side of that is things like conservation zones as opposed to our residential zones provide that extra protection. And also, you know, I say cynically, but where there's the opportunity for influence in negative ways, there's also the opportunity for influence in positive ways. And so to the extent that I can be advocating for our community and making very clear the importance of nature and tree canopy to our community, particularly just drumming on about that, given that things will be potentially going through the Housing Delivery Authority, I will continue to do that. But I think all in all, it's not great news. But Part 3A no longer exists. We've got this now, but it was overturned for a reason, and that's because the community lost trust in the planning system. So I think the campaign for change and for defining what this is and getting community voice back really starts today, and that's something that I will sustain over time. But I'm sorry that I come with not great news about that. I do think one of the best features about us is that we're on a peninsula. There's one road in, one road out. Compared to the rest of Sydney, even if we do have blanket planning laws, we have, you know, nuances with our geography and bushfire zones and so forth that do make it not the ideal site, I think, for development. Having said that, even concerns around bushfire considerations were going to be moved out of the Act and part of this one-stop shop. And Michael Regan was successful in moving an amendment to make sure the bushfire considerations remain in the Act. So we've done what we can, given that Liberal and Labor went together. But I'll bet you bottom dollar we can't have the Liberal Party saying that they're going to be protecting Pittwater anymore, because proof's in the pudding on this week of Parliament and next week when it passes the upper house. So I'll do what I can, and that's something that I'll be working with the council on. And as you mentioned, that the new LEP, but a lot of what is going on with this state-based planning will be undermining local controls and undermining community voice. But you know, the fight starts now, I suppose. So yes, I'm sorry to be the bearer of that news.